Welcome to this episode of the Sangamon County Circuit Clerk Presents. I'm Betsy Moore. The following program is one in a series of programs on various topics of public interest that concern the Circuit Clerk's office, their various departments, and the issues they deal with. These programs are produced for your benefit in the hope that the information contained within will help you better understand the role and the scope of the Sangamon County Circuit Clerk's office.
Good afternoon. I'm glad everybody could show up today. You've all gathered for the seminar today on the discussion regarding landlord-tenant law and eviction basics. My name is Michael Durr. I'm with the firm of Scrohan, Rahan & Durr here in Springfield. And again, I'm very glad that you were all here today. Eviction law. Before we get into the actual details of the eviction law, I want to talk about some of the basic concepts as to what is going on when we do an eviction. When a person owns a piece of rental property, a piece of real property, or any property for that matter, let's say your own house, there are two legal rights in that property. The first, like a brick, is legal ownership. You own the home, you own the real estate. The other right that you have in that property at the very same time is possession. The right to use the real estate, the right to exclusively go in and out it to the exclusion of everybody else. So for example, for those who own their own home here today, ownership and possession are joined together. You own your home, you can go home and you go in and out it anytime you wish. But in the rental situation, when somebody rents a residential property, let's say, to somebody else, it's split. The landlord will retain the ownership, and the tenant takes the right of possession. Now that right of possession is given to the tenant, usually through an agreement. Sometimes in writing, sometimes verbally. That's called a lease. A lease is simply a contract giving the right of possession from one person to another. In most cases, that right of possession is given in return or exchange for something else. Commonly, money, and that is called, otherwise, as we all know, is rent. So the tenant pays the rent, has the right of possession. The landlord retains the ownership. Now, what happens when there is a violation of that rental agreement? Or, as we're going to discuss more in detail today, what happens if the lease, a term of that contract simply ends? And the landlord, under that agreement, is lawfully entitled to reclaim this right of possession. In Illinois, before the advent or the creation of the Eviction Act, what would happen commonly is the landlord would hire people to go into the home forcibly and displace the tenant and his or her family, and the result was there was a lot of violence. So the Illinois legislature, many, many, many years ago, said, we have had enough of that. We do not promote violence in reclaiming possession and ownership. So what we're going to do is we're going to create a statutory procedure that allows the landlord in a relatively timely manner to lawfully regain possession with his or her ownership, while at the same time affording the tenant some rights and some opportunities. And that is the Eviction Act. The formal name of the Eviction Act, and I'm going to refer to it today, by the way, as the Eviction Act, is the Forcible Entry and Detainer Statute. And for those who are following today and wants to hear the stats, I will be calling out the citation numbers to the Eviction Act. Specifically, The Forcible Entry and Detainer Act is found in Illinois statutory or written law, which I have a copy of it here. It is Chapter 735 of the Illinois Compiled Statutes. Within that chapter, 735, it is Article 9. So if I refer to a section of the Eviction Act here today, it is in reference to Chapter 735 of the Illinois Compiled Statutes, Article 9. Okay. Again, this is where you find the Eviction Act, and if you want to peruse through that, you're more than welcome to. We're going to discuss a lot of it here today. Now, with that basic overview, the goal here is rejoining possession and ownership together in a lawful manner. The Eviction Act is very unique in some ways. It is what's called a jurisdictional statute. And what I mean by that is this, that if the procedures in the act that we're going to discuss today, for example, for an eviction, are followed correctly, the court must issue an order rejoining possession and ownership in the landlord. Conversely, if the procedures are not properly followed, the court does not have the legal power, what we call jurisdiction, the legal power to enter an order giving the landlord back possession of the property. And that, folks, is what we're going to talk about here this afternoon. Now, to do an eviction, step one. The first thing you do, if you are the landlord, in attempting an eviction is ask the question, why am I evicting the tenant? Why do I want to use the Eviction Act to rejoin possession with ownership? Now, the reason for that is because the answer to that question will determine the next step. So, for example, why do I want to evict the tenant? Such as non-payment of the rent due under the lease agreement. That's usually the most common. Another reason, that another term besides the obligation to pay rent has been violated. For example, say the lease says no loud parties after 10 p.m. and you're standing out there in your robe at 2 a.m. with the police sergeant out in front of the premises because there's been a large party. Or the lease has expired and the tenant has refused to move, still retains possession, has not delivered it back. That's another reason. Or sometimes, as a lease term will lapse in a month-to-month scenario or a week-to-week scenario, which we're going to talk about more in detail this afternoon. Again, if the tenant retains possession after the landlord has lawfully done the steps to reclaim the possession, again, that may be another reason. The importance of that question is this. The answer to the question determines step 2. What type of notice? What type of notice do I have to give the tenant? Let's break it down. The first and most common type of notice is for non-payment of rent. Commonly, if the lease does not say otherwise, and I'll get to that, If the lease does not say otherwise, the notice required under Illinois law is a minimum 5-day notice. 5 days for non-payment of rent. And for those out here today that are following, again, the stats and the citations to the Eviction Act, that is Section 209 of the Eviction Act. Section 209. Simply, the landlord must provide notice. All notices that we're going to discuss today have some elements in common. All must be in writing. Nothing verbal will count in the Eviction Act, first and foremost. Second, it must be signed by the landlord or his, her, or its agent. That, folks, is important because that precludes notice by email. That precludes notices by texting. Must be in writing, must be signed. 3, all notices must identify or name the tenant. 4, all notices we're going to discuss this afternoon must identify the premises, must put the address at a minimum of the premises on that notice. So, to recap, proper notice, different kinds. We're going to discuss what do all have in common. Must be in writing, must be signed, must identify the tenant, and must identify the address of the premises in question. Okay. Back to our discussion on rent. The 5-day notice. Now, the 5-day notice must state that in the event that rent is not paid in full within 5 days, then the landlord may use the Eviction Act to seek a court order to reclaim possession of the premises from the tenant. The 5-day notice is a friendlier statute than some of the ones we're going to talk about this afternoon. Because here's what it says to the tenant. I'm a 5-day grace period. From the day I'm served, you have 5 days to pay the rent in full. And very specifically, folks, what keeps the eviction, and if you, by the way, if you pay that rent in full within 5 days, I am now null and void. So, the thing to remember for landlords and tenants is this. What precludes the 5-day from becoming a reason to use the Eviction Act to reclaim the premises? Payment of full on the rent in full within 5 days. In full within 5 days. Anything less allows the landlord to go on to the next step, the lawsuit, which we're going to talk about here shortly. In other words, some examples. Say the rent's $500. Say the notice is served. On day 6, the tenant pays $500. 6 days after service of the notice. The landlord can still evict the tenant. The landlord can take the rent, still evict the tenant. The rent claim will be 0. Okay? Right, no, nothing extra. 0, because you've received the money that's due. But the reason you're allowed to do the eviction is simply because it was not paid within 5 days. Again, in full within 5 days. Conversely, say the tenant pays $499.99 within 5 days, but doesn't pay the extra cent within that 5-day period. Landlord's rent claim is 1 cent, and the landlord can still evict. Again, in full within 5 days is the only thing that de-arms this notice. Now on counting service days on notices, service days. So what do we mean by 5 days? You do not count the first day, you count the last. What does that mean, Mike? What's today? Today's Wednesday. Thank you. Today is Wednesday. So let's say today we serve a tenant a notice, whether it's a 5-day or any of the other ones we're about to talk about. Here's how we count. If you serve a notice today, and today is Wednesday, on a 5-day notice, Thursday, Friday, Saturday, Sunday, Monday at 11:59 is the end of that 5-day period. Again, if you serve it on a Wednesday, Thursday, Friday, Saturday, Sunday, Monday at 11:59. That would be the time period for that 5-day notice that we just served in our hypothetical. Okay. Another type of notice. So our first is the 5-day. The 5-day is curable, payment in full within 5 days. Second type of notice. Our second type of notice is the 10-day notice, and that is for violation of any other provision of a written lease other than the obligation to pay rent. A 10-day is not as friendly as a 5-day. What do I mean by that? What I mean by that is this, with one exception. A 10-day is not curable. Let me give you an example. For example, let's say the lease says, no animals are allowed to be at the premises, not even to visit, much less live there. And say the landlord goes over to the house and opens the door to change the furnace filters and sees a Great Dane in there the size of a small pony. Is that a violation of the lease? No animals to be at the lease premises, not even to visit, much less live there. Yes. So in order to terminate the lease for that ground, the landlord has to serve a 10-day notice. Now, again, for those following and keeping the citations, that is Section 210 of the Eviction Act, 210. And importantly, in Section 210, it tells you how to write the 10-day notice. 10-day notices are a lot harder than 5 days. In fact, 5 days, I failed to mention. 5-day notices, actually, if you run a form, you can actually get that off the Sangamon County Circuit Clerk's site under forms. I believe they do have the 5-day notice that's available. You can use, but they don't have a 10-day. Well, what form do I use for a 10-day? Well, consult with an attorney that knows how to prepare one of those properly, or do your best to follow Section 210. It's going to tell you how to write it. But it essentially has to state, in addition to our basics, in writing, signed, naming the tenant and naming the land and premises, okay? In addition, it has to state what the violation was. And further, it has to state the provision of the written lease that was violated. So in our example, on November 1st, 2013, management discovered a dog being kept within the lease premises and violation of provision or Section 2 of the lease, no animals shall be allowed at the lease premises, not even to visit, okay, without written permission. So that would be kind of a basic example. The 10-day, with one exception, which I will address for you out here that it applies to, a 10-day is not curable. So let me give you an example. Let's use our example. So the tenant is served today with the 10-day notice. Doesn't move. A landlord goes to step 2, which we're going to talk about, filing suit. And the tenant says, Judge, I received that 10-day notice, and yes, I did have a dog there, but the minute I got that 10-day notice, immediately I gave that dog away to somebody, to another home. I got rid of the dog. I complied with the lease. Eviction still issues. A 10-day is not curable. Unless, yes, I don't know how many of you today out here, I'll give you a show of hands, the mobile home park owners or mobile home park managers. Okay. Yeah, okay, hi. The mobile home park managers, listen up on this. If there is a violation of the lease in that scenario, before you can avail yourself of a 10-day notice, you have to first serve in writing a 24-hour notice to cure the violation. Yes, and that is a completely separate act that pertains only to mobile homes. And folks, just to make sure we're clear, the definition of a mobile home under that particular statute is any real estate that has 5 or more mobile home lots that are there to harbor mobile homes for rent. 5 or more. 5 or more mobile home lots. If you're 4, you're not a mobile home park. Under the law, it doesn't apply. If you have 5 or more, you are a mobile home park. It applies. 24-hour notice for violation of a lease provision and allowed to cure within 24 hours before going to the termination of the lease with a 10-day notice. Okay. Another one is the end of a 30-day notice, a month-to-month tenancy. Let's talk about that. What's a month-to-month tenancy? A month-to-month tenancy is a tenancy that starts at the end of a regular lease term. So for example, we're in November. Let's say, for example, the lease ran from November 1st, 2012 to October 31st, 2013. Okay. Now, unless the lease says otherwise, unless it automatically renews, at that point, the lease, well, under section, for those who are keeping count, section 213 of the statute, the landlord has the following election, unless, again, there's an automatic renewal in your lease, which I hope there's not. Here's the landlord's election. 1, offer a new written lease for a different term. 2, accept rent for the next month after October 31st, which creates a month-to-month, which I'm going to explain here in a second. 3, immediately sue to reclaim possession of the premises. Well, what kind of notice did I need for that? You don't need any. Except for a quick demand under section 102, which is a basic demand for possession of the premises that's required, but that's going to be a different seminar. The landlord has 3 choices. New lease, accept rent for the next month. Without a new lease, written lease, creates a month-to-month, or regain possession of the premises. Now, in our example, let's say the rent's $500. The lease expires October 31st. November 1st, I pay the landlord, I'm the tenant, I pay the landlord $500. Here's what I've done. I've bought a block of time. November 1st to November 30th. And let's say on December 1st I pay. I just bought another block of time. And let's say on January 1st, 2014, I pay another $500, and the landlord takes it. I just bought another chunk of time. A month-to-month term are buying blocks of time, just like these bricks, blocks of time. Okay, now, commonly asked question, what about the lease that says, I hear this a lot, the lease is expired. No, the lease has not expired, the lease term has expired. So if it's over October 31st, the lease term has expired. So let's say you have a written lease that says, no animals shall be allowed in the premises, not even to visit. And we're in December 15th, and I have a rhinoceros there. Does that provision still apply? The answer is yes. The only thing that's month-to-month at this point is the lease term or length. Now, this will be worth your attendance fee today. you didn't pay anything, but it'll be worth it anyway if you were. You have to terminate a lease, a month-to-month term for any reason with a 30-day notice. 30 days. And you have to do it prior to the beginning of the last full month to be terminated. For example, if this is October 31st, this is November 1st. The moment I paid $500 in our example, I just bought this block of time. But let's say on November 22nd, you want to end this lease, and you heard somebody say, oh, I have to give them a 30-day notice. Remember this example. You cannot cut down the middle of or side of any brick. So if this is the 22nd of November, right here, you don't give a notice on November 22nd to be out December 22nd. That's not how it works. People are like, well, that's 30 days. 30 days is misleading, and please watch this. That's not right. If rent's due the 1st, as in our example, first, you give a notice on November 22nd to be out December 31st, January 1st. Why? Because that's the last full 30 days. You can't cut down the middle of a brick. Okay? This is the brick that's being terminated. So, November 22nd, not to December 22nd, November 22nd, December 31st. And that's your last day. Okay? Everybody understand that? Okay, thanks. Two others are the 7-day notice, which is used only in a term of week to week, not month to month. That's where the tenant pays weekly. Well, where do you find that? A lot of times you'll find that in suites or hotel situations that, rent to people on a monthly basis. And what if, in the situation again, the lease is expired or somebody is in possession with two things? One, no rent was ever reserved, agreed upon, or paid, and two, no time was ever definitively fixed for their stay. You can do an immediate immediate notice for possession of the premises. Immediate notice for possession of the premises. And that is in section 102. 30-day notice, again, for those who are following here out there in the stands. Section 207 for a 30-day. Section 207 for a 7-day. All right. Any questions? We're going to take those at the end. So any questions? Okay. But again, we've gone through two parts of our eviction procedure. First being the proper question, why am I evicting the tenant, and the proper notice. And in just a second here, I'm going to start the part on the second half of this, which is the lawsuit.
Thank you for watching this episode of Sangamon County Circuit Clerk Presents. These programs are produced for your benefit to help you in your interaction with the court system. They're accessible on the Circuit Clerk's website and YouTube channel, as well as the City of Springfield's Public Access Channel 4. I'm Betsy Moore.